Thank you so much for joining us. My name is Morgan, and I'll be moderating today's conversation about what the CPRA requires and how your company can move the needle on compliance today. Specifically, we'll be exploring the differences between CCPA and CPRA, the role of the California Privacy Protection Agency, the technical implications of do not share, and how your company can prepare. So, got a lot to cover. It's only 30 minutes. So we're going to try to dive right in. With the January 1, 2023 deadline approaching fast, this is one of the most topical issues in privacy compliance today. Our speakers today are Brandon Wiebe, Transcend's General Counsel and Head of Privacy, as well as Transcend's co-founder and CEO, Ben Brook. So in terms of how we'll structure today, we'll be starting at the macro level, looking at how CPRA amended CCPA and how this will affect compliance moving forward. Then we'll jump into the role of the CPPA, or the California Privacy Protection Agency, looking at their latest round of rulemaking, as well as what enforcement might look like. Next, we'll take a microscope to the CPRA's Do Not Share mandate, exploring what this will require and how it's raised the bar on the technical aspects of compliance. And finally, and I think most importantly, we'll leave you with a few steps that will help you start preparing for CPRA today. And remember, you're encouraged to drop questions into the Q&A or the chat. So as I mentioned, we're going to start with a wider view, exploring how CPRA amended CCPA and how this will affect compliance moving forward. So Brandon, I'll start with you. How did the CPRA expand the consumer rights provided by the CCPA?
Thanks, Morgan, and thank you everyone for being here. Ben, excited to chat with you as well. So CPRA, just by way of background, for those who don't follow it quite as religiously as some of us, it was a law that was passed by ballot initiative in November of 2020. And the CPRA effectively amends the California Consumer Privacy Act, which is the current California privacy law on the books. CCPA was passed back in 2018 and first went into effect in 2020. As a reminder, so the CCPA created 6 specific consumer rights. They were the right to know what personal information was collected by a business about a consumer, the right to delete that personal information, the right to opt out of the sale of personal information, which had a very specific definition under CCPA, the right to opt into the sale of personal information if you were under 16, and then the right to non-discriminatory treatment if you were exercising any of these CCPA rights. So you couldn't treat somebody differently because they were exercising these rights, or the right to initiate a private cause of action, very limited to data breaches. So in addition to these 6 CCPA rights, CPRA created 2 additional rights, and then it expanded one of them a little bit. So it created the right to correct inaccurate personal information, and it created the right to limit the use and disclosure of sensitive personal information, which is a new sort of subcategory of personal information. It also expanded the right to opt out of the sale of personal information by adding a new concept called data sharing. And later in the webinar, we're going to dive in a little bit more onto what sharing means specifically under CPRA. In addition to these new rights, 2 new rights and one sort of expanded one, CPRA also established a new privacy enforcement agency in California. So it took the regulatory and enforcement power that sat with the Attorney General under CCPA and moved it over to the California Privacy Protection Agency, the CPPA. Of course, all of these acronyms are only one letter off. And it charged this new agency with the power to draft regulations and operationalize a number of the provisions under CPRA. There were many other things CPRA did beyond just sort of these specific discrete rights. It gives the CPPA, the agency, the ability to perform annual audits on certain businesses to check for compliance with the law. the obligation for businesses to do regular risk assessments and submit those to the agency. It gives the CPPA very broad authority to develop regulations around access and opt-out rights for automated decision-making and profiling. So beyond these specific discrete rights, we see that there are a number of different mechanisms in this new law that are designed to protect consumer personal information.
Awesome. Love that answer. So Ben, you and Mike Farrell started Transcend because exercising, these data rights that Brandon just went over turned out to be a really difficult exercise and sometimes impossible. So from a technical perspective, why is it so difficult to make data rights actionable?
Yeah, thanks, Morgan. And it's great to be here, everybody. Thank you for joining us today. So yeah, modern privacy has 100% become a data governance problem. And in fact, it's probably the most complicated data governance problem in history. Suddenly, we need to be able to operate on one person's data across every disparate system in which their data is stored. And to do that, you need to understand where an individual's data is in the first place. This is very hard. And primarily at first, it's because businesses have complex and rapidly evolving tech stacks. So we all collect, store, and process personal data across hundreds, if not thousands of data systems. And these tech stacks are changing daily. So second, these data systems did not ever anticipate that personal data would become a special class of information, which requires special handling. And then third, across all these different disparate systems, there's nothing that really globally ties a user together across all these different data stores. And so it's a very vexing problem to actually fulfill a user's request to, for example, to delete their data, to opt them out of the sale or sharing of their personal information, to give them a download of all of their data. The tooling was just never there for that. And we've kind of spent, decades as the tech industry building all of the infrastructure to collect and process and mine insights out of this information. But we really didn't have the foresight to think that one day all of this personal data would have to have special layers of governance over top of them. And so what we found is a lot of businesses tried to start out by using very manual workflow processes across data owners, where people would receive tickets, they would have to manually go into different data systems, try to operate on their data. And that just cannot scale, especially as these tech stacks move under our feet. And so privacy has completely changed from, historic process of kind of keeping policies up to date and making sure that you're maintaining legal documentation. And now it's squarely a data governance problem. And with that, there has to be technology that can actually address these new privacy requirements. And so as the laundry list of privacy requirements stacks up and the tech stack keeps evolving, you need a way to kind of map those privacy requirements across that tech stack. And so that is what we've built at Transcend, and that's how we approach the problem, is how can we really simplify these processes by installing into all these different data systems and actually giving our customers the ability to completely understand all of the data they have, and then actually layer in governance rules across that to comply with all these privacy requirements. So it really is truly one of the most complex data governance problems ever. And with that, there has to be new types of technology. So yeah, it's definitely something that is a rapidly evolving landscape, and it's only getting more complex with time.
Yeah, that makes a lot of sense. I mean, there's so much data created before we even realized that these would be issues. So a lot of it is trying to apply a retrospective lens to a very complex issue. So Brandon, this next one's for you. The CPPA recently released a draft on the latest round of CPRA rulemaking. What do businesses need to pay attention to there?
Yeah, it's a great question. And as I mentioned, so the agency was given the authority to draft a pretty large set of regulations under CPRA. Some of it was a sort of blank check regulatory authority in some areas. given the volume of regulations that were required here, what ended up happening is this new agency got started a little later, I think, than they wanted to. And so we have now the first in what we expect to be sort of 2 sets of regulations that are going to be required under CPRA. This first set came out about a month ago. It is in a 45-day comment and notice period now. CPRA actually intended for all these regulations to be finalized by July 1st. It's clear that that's not going to be the case now. And this first set of regulations is as I said, incomplete. We expect sort of more subject matter areas to be covered in a second package of regs. But from what has come out, we do get a lot of insight into some very specific areas, particularly areas of compliance that are going to require, I think, a lot of technical lift from businesses. So just at a very high level, and we'll try to dig into these a little bit more as we continue to talk here, but at a high level, the ones that I would be focusing on, if I were a privacy professional working on getting ready for compliance for January 1st, is operationalizing opt-out mechanisms for the sharing of data. So this new expanded right around the right to opt out of sharing, as well as operationalizing limitations on processing of sensitive personal information. The regulatory package that came out right now, these draft regulations, got into some detail around what sort of opt-out mechanisms are acceptable and how businesses can begin to start putting those together. The other area that I would really focus on is around dark patterns. So this is a term that's come up a lot in the news. CPRA and these regulations in particular focus on dark patterns, and the CPPA lays out some guidelines on what they consider to be a dark pattern and how businesses can go about identifying those and eliminating those. They also lay out kind of what the consequences are if you do use dark patterns to try to obtain consent, or use dark patterns in your interface where consumers are trying to exercise one of their privacy rights. And there are some significant consequences for that.
Yeah, that makes a lot of sense. And I know this is a little bit speculative at this point, but based on past precedent and the global arena, what do you imagine CPPA enforcement might look like?
Yeah, it is early to know exactly what the enforcement process will be like, and how active CPPA will actually be in that process. We get a little bit of a glimpse from the statutory language as well as this most recent set of draft regulations. So we do know under CPRA, fines for unintentional violations of the law are $2,500 for each violation, and for each unintentional violation, and $7,500 for each intentional violation. There are also $7,500 automatically for any violation involving a minor's personal information. So if CPPA is getting involved and investigating a violation, you can expect that the volume of consumers that might be passing through your website could cause the number of violations to go up substantially and the monetary value to be pretty significant. We also know under CPRA, there was a 30-day cure period that existed under CCPA. That has been eliminated under CPRA. So it used to be that a business had 30 days to cure a potential violation before being fined. That's gone now. So it really means that businesses are kind of on the hook, and sort of the initial period of 2 years of a California privacy law seems to be enough for any grace period to no longer be required for businesses. And then the draft regulations also put together some procedural rules around what investigations might look like from the agency. So those regulations say that the agency can initiate investigations on its own accord, or through responding to non-sworn and anonymous complaints. The agency also has an obligation to respond directly to any sworn complaints that a consumer might submit to it. So you could imagine that given they have that obligation, the volume of complaints that might come through and the number of investigations that might get launched from this could be pretty significant. The agency also has the right to audit with or without notice certain businesses to ensure compliance with the law. So I think it does remain to be seen like how active this is and what businesses the CPPA begins to focus on first. But you could imagine the agency developing into a really highly active data protection authority, very much like the DPAs that we see throughout Europe, for example.
Mm-hmm. Yeah, that makes a lot of sense. So in the interest of time, I want to keep us moving on and take a bit of a deeper dive on the do not share requirement, something you mentioned earlier, Brandon. But Ben, I was hoping that you could give us a little bit more information there. You know, in the context of increasingly advanced ad tech, how has this affected the technical side of privacy compliance?
Yeah, so it's an interesting, it's a very interesting implementation here. So to actually stop sharing and actually comply with the user's opt-out choice, you need to be able to stop sending one person's data downstream to an ad network or to all of the ad networks. And so this today mostly occurs in businesses in the form of automated pipelines that are collecting personal data and then transferring that to ad networks. And so now we need to be able to actually encode new logic on those pipelines to encode that user's opt-out choice. So basically, complying with this is kind of like installing valves on pipes so that you can actually shut off those pipes. So if you imagine you have, let's take Facebook, for example, one of the ad networks, which would be part of the do not share requirement. You have probably many pipes going into Facebook, and for each of those, you need to find a way to shut off the valve for one user when they have opted out. And so logically, we can kind of start from the question of where do we have those pipes as a business and where can we install our valves? And so within that, there are three classes of problems, really. The first is client-side data collection. This is where there is a tracker that is embedded on an interface like an app or a website. And that pipe actually goes directly from the user's device straight to Facebook or to Google or to Pinterest or what have you. And that is being collected through technologies like Facebook Pixel or the like Google, the Google equivalent. And that is going straight from client to the ad network. The second type of problem is back-end data transfers. And so companies will also collect data into their own systems and then subsequently send it downstream to Facebook ads, such as lookalike audiences or something like that. Again, you have to be able to install a valve there. And then the third class of problems is human processes. So a lot of marketing teams will export lists by hand and then upload them directly into Facebook. And so for each of these, you have to have a governance control to actually encode this user's opt-out. So when a user says do not share, there has to be a control on that valve, on that pipe from the client to the Facebook server or to the Google server. And that means actually deploying a control right onto the front end that will detect the user's opt-out choice and then actually stop sending events to Facebook or Google, or otherwise change the nature of those events that are being sent. The second then for backend encoded transfers, there has to be an opt-out list that a backend service can read from, and that they can then actually control and filter the logic based on, if this user has opted out, we will not send this user to Facebook or to Google. And then again, for the human processes, similarly, there needs to be a list against which marketers and people uploading data to Facebook can cross-reference their data against and actually suppress any of those uploads in that event. And so for each of those, there is a technology associated with that. So on the client side, there are technologies that you can install onto your website, onto your app, that can handle the opt-out and actually change the nature of data collection for that individual user. So at Transcend, this is our consent manager, and that would actually alter the way that data is collected to Facebook for any user who has opted out. For the backend process, you need a record of consent that you can actually maintain a list of the users who have opted out, and then have your backend processes read from that, filter the list, and then upload to Facebook. And then for the human processes, again, that record of consent has to be used. So all of this is very much based on having the right technologies in place for CPRA and for any other sort of modern privacy requirement that may come. You need to have new governance controls across all of these different pipelines that exist in your business.
Yeah, that makes a lot of sense. I love a good metaphor, and the pipeline definitely helped. So with all this context, I want to turn to the heart of our discussion today, which is how can companies prepare for CPRA? Brandon's actually written his own guide about this subject, which we'll be sure to send out after the event. But the three kind of most important steps he identified are: 1, creating a data map; 2, determining whether you're sharing personal information and then implementing an opt-out mechanism; and 3, cleaning up your dark patterns. So Brandon, I'm hoping you can take the first one. What is a data map, and why is it so important for CPRA compliance?
Yeah, absolutely. So a data map itself is not actually a regulatory requirement of CPRA. It has been used in the past for other privacy law requirements, like under GDPR. You would use a data map maybe to create records of processing. But under many other laws, including CPRA, it's not strictly required. A data map is simply a set of documentation that shows you the types or categories of personal information that you're processing, how and where you're processing that personal information, and why you're processing that. It can take many forms. It can just be a spreadsheet that you manually update. It can be automated and tied directly into your tech stack in a way that allows that documentation to be dynamically updated as your teams add new vendors or change the type of data processing that's happening. But the reason that a data map is really important, and why I think of it as kind of step one of any data privacy compliance program, is you're going to need to perform a gap analysis between your current processing activities and the law or regulation that is out there. And to perform an effective analysis, you need to have a complete and accurate picture of the actual processing that's happening at your company. One of the biggest roadblocks I've seen to actually kicking off the compliance process is privacy practitioners like me. We go to webinars, we read up on the regulation, we understand the law really, really well. And we take all of that information back to our organizations. And then we don't really know what to do with it, how to apply that to the actual processing that's occurring, because we don't have a complete picture of what's going on. And so if you're really going to build a compliance program that you feel confident meets the requirements of a particular law, you have to start with a complete baseline truth or surface level truth of what's actually happening in your business from a data perspective. So a data map is a great way to do that, to get started on that. It also makes ongoing compliance as your data processing practices change over time much easier, because you'll have this map that gets updated and you can use that to assess changes and compare that to the current state of the law.
Yeah, that makes a lot of sense. I mean, it just reminded me of what Ben was saying at the beginning about how this is a data governance problem. If you don't know what data you have, then clearly you can't govern it. And, Ben, data mapping is clearly a complex exercise. How can companies create an accurate data map?
Yeah, scanning technologies are the key. This needs to be the foundation of every company's privacy infrastructure. The status quo right now is actually kind of to hire a contractor to come and interview every data owner in the organization. And that's based on like human testimony, and it's really a fuzzy picture at best, and it takes months to complete. And then of course it falls out of date immediately, because these tech stacks and data storage schemas are changing almost daily. And it's actually much easier just to scan for your data rather than have people try to describe it to you. First, it's accurate. And so you get base truth on what data you have right down to that field level. And second, it's up to date. So scanning gives you a near real-time representation of all the data in your business. And so having a specific and accurate and up-to-date data map will set you up for success in every subsequent privacy project. As Brandon said, it's really step one for everything else. And so, that might be creating a record of processing activities or setting retention policies, handling privacy requests, handling do not share requirements. And so it's really kind of the foundation of a privacy program, and you want that foundation to be solid. So scanning technologies are really the key to doing this and to getting that live base truth of what you have in your business. And so you need to be scanning not only for what systems you have in the first place, but also what is inside each of those systems right down to the field level. And so using a technology, we built something called Transcend data mapping. That is scanning technology. It goes through, catalogs all the different data silos, catalogs all the internal schema, and then classifies all the data inside of it, and builds for you a complete global picture of all that information. And then that then flows into every other area of governance. So in Transcend, that means we're giving you smart suggestions about how to update your deletion workflow or to change your do not share consent governance rule. If we detect that there's a new ad network, of course we want to change the governance rule associated with that. And so having those live scans is really it's critical. And I think the industry is already starting to do it, but moving away from the sort of let's go interview every data owner process is really the next big leap for the industry right now.
That makes a lot of sense. So we are coming up on time a little bit, but I'm just going to keep going. If you do need to hop off, we will be sending a recording of this out afterwards. So just so you know. Moving on, Brandon, we touched on the idea of do not share earlier, but can you tell us a little bit more about the practical ways in which organizations can prepare for this requirement?
Yeah, absolutely. So the do not share requirement is this net new sort of expansion of the right to opt out of a sale of personal information. Under CCPA, a sale of personal information was the exchange of personal information for monetary or other valuable consideration, which was a little confusing of a definition. And there were instances where maybe you were sharing information with an advertiser and they were using it for some broad cross-context behavioral advertising, for example, but there wasn't necessarily an exchange of consideration. And so that fell outside the scope of a sale. The new sharing requirement really gets right in on that sort of use case. Sharing under CPRA means the transfer of a consumer's personal information to a third party for the purpose of cross-context behavioral advertising, whether or not it's for monetary or valuable consideration. Cross-context behavioral advertising is really advertising using a consumer's personal information gathered from their activity on one business or one website to advertise to them on a different business or a different distinctly branded website. So really, if you're going to take steps now to start a compliance readiness workstream for opting out of sharing, you have to start with your baseline truth, your data map. And so step one or phase one is really to look at your current data processing activities, identify the areas where you are sharing information to third parties or vendors, and analyze each of those to see if it meets the definition of sharing. There are some places where you can start looking first. Most of this cross-context behavioral advertising sharing is occurring through integrations directly into advertisers. So those could be client-side integrations on your site, could also potentially be server-side integrations on your back end. And so you can use your data map that outlines all of these different processing activities to begin to identify those. That would be phase one. Phase two is once you have a sense of what sharing might be occurring, is to identify how to implement an appropriate opt-out mechanism. I won't go into excruciating detail on all of the regulations right now, because I know we're short on time, but I would encourage everyone to go and read the opt-out regulations and the mechanisms that are available to businesses for allowing consumers to exercise this sharing right. In particular, I'll highlight that under the CPRA statute, the obligation for a business to respond to what's called a opt-out preference signal, which is a signal sent by a consumer's browser automatically. That was optional under CPRA. Under the regulations that have just come down, the draft regulations, the CPPA has said that businesses must respond to these opt-out preference signals. And there are also several other US state laws that suggest that responding to these opt-out preference signals is going to become mandatory in the next few years. So now is a really good time to start to explore what it would take from a technical perspective to implement an opt-out mechanism that respects and responds to these universal opt-out signals from browsers.
Yeah, that makes a lot of sense. And Brandon mentioned a little bit about the opt-out mechanism. Can you tell us from a technical perspective, like what that could look like?
Yeah, so there's kind of two halves. One would be how you collect the opt-out itself. And then the other is how you actually implement the choice. So it's one thing to have a user go through an interface to offer an opt-out or to opt out of that, do not share, for example. Then it's another to actually govern all of your data flows on the back end to make sure that you're not collecting it. And so for the former, it's as simple as putting an interface on your website. CPRA is very prescriptive about how this works, and this will be detailed in Brandon's blog post. I won't take up your time on that, but this is essentially just a footer in your on your web page. It says, "Do not sell or share my personal information." A user should be able to efficiently move through that flow and make that opt-out choice. And then again, on the back end, as I mentioned, it's making sure that you understand all of those pipelines and then actually having the valves in place on those pipelines to ensure that you're not sending data or sharing it to, for example, an ad network, but really any party that would meet that definition. And that's really the place where technology is very important, to have a really good platform in place to collect these preferences and to actually encode them across your stack. So there's lots to unpack there, but that is essentially how you should approach this problem.
Yeah, that makes sense. Thank you. And Brandon, this last one's for you. Can you give us just a brief definition of dark patterns, and then tell us a little more about what the CPRA says in relation to dark patterns?
Yeah, definitely. So dark patterns is a new concept. It's been talked about a lot. There have been other federal agencies, for example, that have talked about looking for dark patterns and applying their existing authority to try to eliminate those. But CPRA defines a dark pattern as a user interface that is designed or manipulated with the substantial effect of subverting or impairing user autonomy, decision-making, or choice. And then it says, as further defined by regulation. So this draft set of regulations begins to flesh out some examples of when the agency thinks that a dark pattern might exist. And then it talks a little bit about what the consequences of using a dark pattern are. So I'll start with the consequences first, which are you are not allowed to use a dark pattern interface to obtain consumer consent. The effect of that is that the consent is void. And so if you are relying on that consent to collect personal information, you are doing it effectively without consent. And so there can be consequences from that. The regulations also state that you are not allowed to use dark patterns in any of your mechanisms that allow a consumer to exercise their rights under the law, their privacy rights under the law. So in their opt-out of sale or sharing mechanisms, you cannot use dark pattern type of interfaces to try to steer a user away from exercising their rights, for example. The regulations state, they give sort of 5 broad ways in which a user interface could be a dark pattern. So to avoid a dark pattern, you have to use methods and language that are easy for a consumer to read and understand, provide symmetry and choice. So for example, rejecting all shouldn't be more difficult than accepting all. Avoid confusing language or interactive elements. Avoid manipulative language or choice architecture, like copy that guilts or shames somebody into making a choice. Like, no, I prefer to pay full price buttons, and use easy to execute methods. Some of these are a little wishy-washy, and one of the public comments at the last CPPA public hearing asked the agency to adopt sort of a more objective legal standard, like practices that would amount to consumer fraud. We'll see if they amend their regulations in the next draft that comes up. But there are also some things in here that are pretty straightforward and I think easy for us to understand, like the symmetry and choice requirement. And if you think about all of the cookie banners or opt-in banners that you see out in the wild right now, many of them do have sort of an accept all or a more information type of architecture. Under the dark patterns regulations put out by the agency, any of the consent obtained through that would be void sort of at the outset. So though dark patterns sound kind of ominous, I actually think as we go through this analysis, we're going to find that there are a lot of instances where current businesses are employing dark patterns in what they consider to be an innocuous way, but we're going to probably have to address those. So step 1 for businesses is to start looking at where you collect consent, what your opt-out mechanisms look like, and then doing an analysis under this to see if there are some design choices that you can make with your user interface and user design team to make the choices a little bit clearer or easier to understand for consumers.
Yeah, that makes a lot of sense. Thank you both so much for your insight. You know, as I mentioned before, Brandon has written an in-depth guide on the same subject, going a little bit deeper on some of the things that we spoke about today, as well as a few others. So we'll be sending that out along with the event recording after the session. And we do have a couple great questions in the chat, but in the interest of time, we'll be following up with those folks afterwards. So Derek, David, and Charlotte, we see you and we'll follow up with you afterwards. Ben, any closing thoughts on how companies can best prepare for CPRA?
If you haven't already adopted technology in this space, now is the time. CPRA is one of 5 state laws, a lot of which read in the same way, and one of many, many laws around the world. And so these privacy requirements are stacking up faster than anyone could possibly keep up with. And so finding the right partner in the industry that can help you encode these requirements into your tech stack and actually help guide you through these processes is really critical. And it's the only way to actually solve this in a future-proof way and actually solve it thoroughly across the tech stack without burdening, you know, a massive engineering team onto this project. So if that's something that you are interested in, please reach out to us. We'll have our contact info in a moment. We'd be glad to, you know, talk through a more specific implementation and how we can help.
Awesome. And Brandon, same to you. Any closing thoughts?
Yeah, I would echo everything Ben said. I think for folks who know that they are going to have to comply and spin up readiness work streams for CPRA, get started now. We don't know all of the specifics of all of the regulations yet. That's okay. I think we generally know what step 1 and step 2 look like, even if we don't know step 3 or step 4 yet. The clock is ticking. We know enough to begin to scope out what the work will look like. And I do think that starts with getting a handle on where our data processing activities are, building a data map, and putting governance controls in place so that when we do have a clearer picture, we have the levers available to us right now to be able to pull at that time.
Awesome. Well, for both of you, what's the best way to get in touch?
So for me, the LinkedIn on the slide, I'm also at BenCMBrook on Twitter. And then you can also email me at ben.brook@transcend.io.
And for me, the link on the slide is great for LinkedIn. And then my email, brandon@transcend.io, is probably the best way to get in contact with me. I'm happy to talk about this for anyone who's struggling with CPRA compliance or just want to bounce ideas. Always open to those conversations.
Great. Well, thank you both so much for all of your amazing insights. And thank you to everyone for joining. We'll get the recording and Brandon's guide across to you shortly, and enjoy the rest of your day.
Thank you so much. Have a great day.
Thanks, everyone.